There we go. Okay. It is Monday, November 3rd, 2025. This is a meeting of the Land Use Review Board. I am Janet Hurley, the chair. I will ask board members to introduce themselves as I see them on my screen. Brooke.
Brooke Dingledine, good afternoon.
Sarah.
Sarah Had, good afternoon.
Alex.
Alex Weinhagen, hello everyone.
And Kirsten.
Kirsten Sultan.
Thank you. Any agenda updates from board members? I see mostly shaking heads or silence, so I will move along. Thomas, any comments on non-agenda items today?
Thank you for asking. No, I don't.
Okay. Operations, budget, and legislative updates. I'm not thinking of any pressing updates. Are you, Pete?
No, I'll just say we had a wonderful annual meeting last week, which was great. Nice to see a good portion of staff, commissioners, and board members at that event.
Yeah, it was a good day. A lot of interaction between various members of our program. I found it really important. So hopefully we'll have another next year that'll be just as good and maybe better. So Jenny, do you have any updates for us from your end?
Nothing specific other than I have been getting lovely feedback from people about that they thought that the staff or that the whole day was really useful and that they learned a lot.
Great, thanks. All right, well, let's move right along sorry, was that a, no, okay. Funny
There was
noise.
some pinging going on here.
Pinging, okay.
Yeah.
Studies and reports. So we have the appeals study draft report to finish, well, not finish, but to continue discussing. So Brooke, do you want to go ahead and begin?
Sure. I have been chasing down a number of issues, and we have been getting and received a number of public comments and stakeholder comments, many of which are very thoughtful, require some analysis and some need to address some of the issues. One of them in particular was raised at our meeting by Zachary Handelman, and also heard from the judiciary on it as well. And that relates to the notion that recently, I don't know the exact date, but the environmental division jurisdiction was expanded to allow the court to hear property issues, real property disputes, whether it's easements, that kind of thing, that pertain to the project that is under consideration, or that is the subject of the appeal. Because oftentimes they will come into contact with the permitting on the case, and it provides the court with an ability to adjudicate all of those in a more expeditious fashion, as opposed to two-stop shopping where property rights have to be adjudicated by the civil division of the Superior Court, not the environmental division. So the question was raised, what is the board proposing? Are we planning on taking that jurisdiction or proposing to take that additional jurisdiction or not? And if not, how should we, if at all, address that issue in the report? So that is one of the first issues that I want to try to talk about.
Board members?
I personally have no, I don't recommend in any way, shape, or form that we place ourselves in the position of wanting to take on those kinds of legal disputes.
Right.
I agree completely.
I agree. Alex, Sarah, heads nodding. Alex? Yeah. Easy peasy. Next.
So let me ask you another question about it.
Yeah.
So you know how we're giving like the applicant the authority or option to bring over the zoning into to consolidate with Act 250. Do we want in any way to give any latitude to the applicant not to come here if there are property issues involved that the court would have to adjudicate anyway?
Sorry, say that one more time, Brooke.
So what I was thinking is, would we want to even contemplate or talk about giving the applicant the option not to come to the board if there was the need to adjudicate property interests? Like, let them stay over at the court if there were this other dimension of jurisdiction for the court to decide.
And you mean for Act 250 zoning, everything, right? Okay.
Yeah, anytime, whether it's, I mean, anytime that we're normally under this board model
Yeah.
going to get the appeal.
Okay.
Can we have a safe, like a safety valve for them to say, wait a minute, now you're forcing me to go to two different venues because we have to deal with the property
So
law.
what would the view of the court be for us to say, yeah, we'll take Act 250 appeals unless the applicant doesn't want us to do so? Like, is there going to be a feeling that, we'll only, I mean, if we're going to take them, then take them. But at the same time, I don't think we should change our minds about the previous question. So, Alex?
Brooke, I don't know this area of law. Maybe you do, or at least do a little better. In the current model, where the Supreme Court now says the Environmental Division can adjudicate these matters of property law, what happened previously, and can that still happen? Like, presumably it was dealt with in civil court, and can that still happen? Or was the Supreme Court's ruling such that it could only be decided by the environmental court? I was under the impression it was just cases that were in front of the Environmental Division that had a property right issue could be resolved by the Environmental Division, not that that's the only place to resolve property issues.
Right. Their current jurisdiction only pertains to if there is a permitting appeal before them that has this property law dispute dimension to it. That's when they can decide that. Normally, it's just the civil division. Now, one of the pieces of information I'm still trying to figure out is, and need to get an answer on, is how often has this even happened? I can think of maybe 2 or 3 times in 30 years that I can even think of. Well, gee, maybe if we had that easement resolved, this might be easier. But first of all, I don't think that it's a huge number if it happens at all. And I wasn't suggesting like they get to just opt out or choose, oh, I want to stay with the court or I want to go to the board. All that I was saying is, if there is that circumstance where the Environmental Division has to decide property rights, do we say, okay, they can stay there and not come to us if that dimension exists so that they are, but you see, they wouldn't, civil court would have it, right? If the Environmental Division didn't have it. So I'm just trying to figure out if there's some way to alleviate that or satisfy, gee, we're losing that consolidation. I think it will partially depend on, I think it hardly ever happens in a blue moon, but just wanted to present that in case the board wanted to offer any kind of option.
That's my sense of it, Brooke. So thanks for verifying that. And so my off the cuff opinion is that given that I agree. I think it's rare that an issue or an appeal comes down to one of those issues. I'd prefer to have, if the legislature were to send appeals our way as we're recommending, I'd prefer to have the property issues continue to be dealt with on the civil side. And sure, maybe they got to deal with two appeal bodies, us and a civil court. And that's not as neat and tidy as what the Supreme Court now says the environmental division can do. But I think that's fine. I don't think it happens often. And yeah, I wouldn't recommend that we became that arbiter or that that applicants could jump ship and get into the environmental division because that's a facet of their case.
Kirsten?
I agree with most of what Alex just said, except that I do think that there could be compelling reasons why the applicant just wants to stay with the strictly court process. And because it happens so rarely, I'm not really stuck on either model with respect to this detail. I can think of in my, 20 years almost of frontline experience, I think this came up once or twice, that there was a concurrent, property rights question that was in dispute, concurrent with an Act 250 application review. But yes, I think either is fine. I'd be interested to know if, if stakeholders have strong preferences one way or another, because I don't really. But I don't think it would be the board's role to be setting ourselves up to in any way adjudicate, property right questions. That's just not for us.
Sarah?
I would agree that the adjudicating property rights is not for us. That's something that I don't think that we should take. I worry about designing around the exceptions and having the Howard Johnson's flavor variety of ice cream for all these. I think in some ways it should just be, it stays with us. There's not an opt-out, and there might be this odd exception that maybe could be separately adjudicated in environmental court before coming to us, or parallel to us. But yeah, I'm not as worried about it, just given the fact that this is not something that happens very often. But I think that we shouldn't have too many deviations, I think is where I'm coming down.
Okay.
I agree.
Okay. Now, let me throw the next issue at you. This is a big one. The NRC has sent written comments, and it's been good because it's, brought them all together in a comprehensive whole. They've been engaged throughout the process and have been very helpful. So I had it back and forth by email with Don Groveman because I wanted to understand, because I was hearing from some of our housing advocates, Elizabeth Bridgewater in particular, who were raising the flag. They wanted their voices heard more. They're also very supportive of moving to a board model for housing. And so in the course of emailing and conversing about what we are proposing to take, I think that there is a strong, there is a definite preference that the board take housing, not tier 1 everything, and housing everywhere. And I made sure to get a clear answer from John Groveman on this. And I have thought about this long and hard, and I really want the board to consider switching tracks and taking housing and not taking tier 1A everything. And the reasons why is I do think that while it may not have been articulated, maybe hitting the nail on the head, there is some concern about us giving up jurisdiction of Act 250 in tier 1A areas and then reasserting ourselves to become the arbiter or the decision maker of the very permitting that is going on where we no longer have Act 250 jurisdiction. Now, And our charge for the appeals study has nothing to do with it, with anything other than, trying to figure out how to speed up appeals, and particularly to address housing and what we can do to speed up housing. Now, certainly one could argue, no matter what we take, if we're alleviating the caseload at the environmental division, that'll speed things up, though I don't think that that's necessarily a conclusion that everybody agrees with. But I don't feel tethered to just 1A everything. It's zoning. It's not our program. And it can be, anything, commercial, industrial, whatever. And I understand the notion that, yeah, that's where we want development to happen, but that's not the development that we're trying to speed up and resolve the housing crisis through. And I think that the bright line, I was arguing for a bright line before, simply because I like bright lines. But the more that I've thought about it, I don't see our connection to, and the justification for taking all of 1A. I think housing, 1A, 1B, and everywhere would be beneficial. This is what, now, the other thing is that some of the housing advocates actually would like us to take all of zoning, but I think we've all agreed that that is a bridge too far. Maybe through phasing or implementation later, that can be discussed. So that's my pitch. I would propose that we switch zoning to anything that is related to the Act 50 for consolidation, or it's a housing appeal, and we define housing by saying an increase of at least 1 unit of housing. What do you guys think?
Sarah?
I still feel very strongly what I've reiterated last week, and the answer would be no for me, Brooke. And I do believe that there is a strong nexus between having a fast and predictable appeals process for our downtown areas that may include businesses and commercial development on housing and our economic health in general. I think that these are areas that we are going to vet specifically, that we are asking to meet a higher bar for their standards. So I think that those are areas that deserve to have a faster adjudication process. And I do have that same concern of, are we spreading ourselves too thinly, particularly given the limited resources that we're going to have in terms of one accessory dwelling unit here or there. I think we need to focus, and these areas that are going to clear these hurdles as having a higher level of standard or review of bylaws and are stepping up to the plate. I think we should be giving them every opportunity to have an expeditious appeal process. I just see that as being beneficial all around. And I think it also helps reiterate the land use plans that we're trying to forward, where we do want to see as much housing within these areas as possible. Otherwise, I think it's also a nice benefit for tier ones, because it's a difficult process. Why do it as a municipality? And I think for those municipalities that are willing to step up to the bat and be all in, we should be too. Thanks.
I just want to respond by saying the piece that's been uncomfortable for me is this is not within our charge. We were asked to address the housing crisis and housing appeals, and I think that there's an element to this that is arrogant to say, well, we don't care so much about the housing if it's only a couple units in the rural areas. We want to dig into tier 1A when it's not our jurisdiction. That there's something about that just makes me feel very uncomfortable. That's just my response.
So I would say that it's not about arrogance, Brooke. Absolutely not. It's a different perspective to suggest that we may not have we don't want to spread ourselves too thin. We want this to be an effective appeal process that answers the call, right? And taking every single housing appeal, no matter where, no matter how small, potentially could, you know, take too much of our capacity.
Well, I'm thinking the opposite. To me, there are 60 zoning appeals in the court per year on permitting. Only 20 of them are housing. So we have no idea. So if you're worried about the resources and spreading ourselves too thin, I
Mhm.
think objectively, based on the data that we have, and it's not perfect, that's certainly true. But confining it just to housing, to me, is the way to limit the number and the volume. More so than just saying, sure, we'll take everything that ends up coming out of, a big municipality where there might be a lot of cases. That's my concern.
Right. Though, how many tier 1As are there going to be? Not that many, at least not initially. So,
Yeah, but they could be those really big projects, that's my concern. Yeah.
Sarah?
I was just going to come back to the part of, I think our charge is to try and reinforce this tiered Act 250 jurisdiction areas that we're trying to put forward. And I think there should be something to try and be expeditious with tier ones where we are trying to focus development within our future land use maps that we're standing up with our regional plans. And I don't think that it should be the same for a house in a potentially tier 3 area to get the same sort of level of expedited review as a house in a tier 1A area. And I do think that is going to be a lot of housing within these areas. I think we could only be so fortunate to have some more businesses and commercial side, but I think to Janet's point, it's not going to be necessarily the tier 1As. We're not going to see very many of them. It's going to be the tier 1Bs. It's going to be those 50 units or less. And I think those are going to be sizable and they're going to be throughout our villages in um, different areas throughout all of Vermont. It's I think that tier 1B is something that we're seeing as our future land use maps are developed by regional entities and brought forward. There are certainly a lot of them. They're very diversified and they have such a wonderful opportunity for dense levels of housing within already settled areas. I think that's where our focus should be, not on the one-offs in remote areas that could be fairly complicated, particularly for towns that have not invested in their zoning and subdivision bylaws.
I just want to say, it's not just single family homes in tier 3, it's all of tier 2. It's all of the municipalities that don't elect to go to tier 1A or 1B, where there might, anyway. Yeah.
Yeah.
I just don't want it to sound like it's only single family homes that we're
The-
kind of
One
serving.
other thing, Brooke, is that you suggest that our charge was limited to housing, but I don't think that that is the case. The appeal study was to evaluate the transfer of appeals from the environmental division to the board, not just housing appeals. It wants us to pay particular attention to housing appeals, but not limit our examination to just housing. Kirsten.
So I understand the perspectives here. And I also have given this a lot of thought and my position is unchanged. I think that beyond appeals of Act 250 permit decisions, like the next step that the board would take would be to consider all housing appeals statewide that would add, at least one unit of new housing. Just see it as an equity issue because the rural areas, one or two housing units, as I've said already before, that might have some equivalency to a greater number of housing units elsewhere. And I just think it's a bright line. It's fair to me. It feels more equitable. But that's just my own
The other thing I would just
Alex,
mention is
I
there,
just want to,
yeah.
I want to
let-
hear from Alex on this.
I appreciate the back and forth and the discussion. I think I'm largely in the same place I was last time, that you've all convinced me that we need to step into this with a little bit of time and ability to assess as we go forward. So I see the prior discussion and proposal to take tier 1A and 1B as a step in that direction. And should that pan out nicely and everyone think that we're doing a good job, I see no reason that the legislature couldn't take another look at this in a few years and say, okay, now it makes sense for your board to take on housing, because you've demonstrated that you're doing it better and more efficiently than the environmental division. So I'm fine with having it be sort of a two-step process where we start with the tier areas and then potentially expand. And why not have the report say that? I mean, say that we considered both and we want to make sure we do it right. And that in order to do that, we want to focus on the tier 1 areas first, but that we'd be happy to consider having a larger footprint with regard to all housing at a later date.
The other thing I was
Okay,
just
Brooke.
gonna the other thing I was just gonna mention is last time there was a bill for a housing court with 3 judges just to do housing. I think it's just an indication of, what the approach or the thoughts have been on the part of some legislators. So, okay, I got enough information and thank you for considering it. Now there's one other piece of information. I'm not sure where I am on time, Janet, if you could.
Oh, I think you're fine.
Okay.
Yeah,
I think
yeah,
we have
you're
like
fine.
35 minutes or something. Okay. So the other thing I wanted to do, I'm going to share my screen because I wanted to talk about disposition guidelines. I'm going to show you what the court has. Sorry, it's on 2 pages, but this is a guidance chart for the court to their goals for them to be able to process cases within certain timeframes. And these are the numbers that they currently have published and that they measure themselves against. 85% they were under goal and 15% go over goal. We do the same kind of comparison and analysis on our own guidelines within our decision making within our program. So I got some feedback from Alex about what timelines that we should propose for trying to process the same types of cases, although we're not doing enforcement and that kind of thing. And he had some very enthusiastic short time frames, and I just wanted to chat with you all about his suggestions and to come up with some kind of time frame. I don't have 2 versions of this to show you side by side, but as you can see, it's like a year that they
Yeah.
have for appeals. Enforcement cases are a shorter time because they tend not to have so much, discovery or motions. On the record appeals are higher again, and that pertains to the problem that they're having with the getting transcripts made for the courts to be able to review. So I'm gonna pull down to one that I was doing. And the left-hand number is what Alex was suggesting, and I was kind of trying to stretch those a little bit longer to be a little more realistic. But thought I'd just throw the numbers out and see if you all have any thoughts about it.
What
again-
about, Brooke, what about having a range, at least for the Act 250 appeals for minor and majors?
Yep, that's a good idea. Okay. Put a minor. Oops. Well, I'll change the order of them later.
Yeah, yeah, that's okay. Just throwing that idea out there. And right now, I mean, these are recommendations. And we do want to give ourselves enough leeway to resolve these, right?
Mhm.
Without, so can
I'm
we,
gonna put them right next to each other so we can see them.
can we call these guidelines and recommend that they not be written into statute at this time? If you know what I mean?
Well, yeah, I mean, we're the ones who are proposing it.
Yeah.
And the court has these as goals.
Right, they're
They-
goals for us too. Yeah,
Right.
okay.
And then they do measure themselves against it to see if they can accomplish it.
Hmm.
I didn't get any information on how they got to these numbers, really. I don't know how they were formulated because I feel like I'm throwing darts at a dartboard in a sense, you know?
Yeah.
Sure, these sound like long time periods, but when you then incorporate all of the steps in the process and the motions, you know, this is probably based on some kind of reality or history, I would think.
Right. But if we can't shorten those timelines, then what's the point?
Right, exactly.
So,
So I don't think they need to be mandatory, but I
right,
think they need to be realistic. And I'm
right.
not sure how to get to that number.
Well, maybe we can suggest these as they're sort of written as these as um not thinking of the word, as a gradient,
But
or what do you call it?
as a recommendation or a goal
Yeah,
or whatever.
as
Yeah.
recommendation,
Like a
but
performance standard?
a range, I'm sorry, a range, that's the word I was looking for.
Oh, okay.
And that we can plan to evaluate this as we go along to be sure that they're realistic, and if we can do better, you know, maybe we could even lower some. So Kirsten, your hand is up.
Yes, I'm just looking for a little bit further explanation from Brooke as to the way it's presented is or, 90 or 120, 150 or 180. Are you,
Oh,
do you think that it would be, I mean, I just heard Janet
just
refer to maybe identifying a range, but do you think that it would be helpful to pick a number, and are you thinking the board should do that? And I was just gonna, as a comment, I guess I'm just, this is a little off the cuff, but like the JO appeals, 90 to 120 days, like that seems like that's a lot of time. I mean, would hope we could do them in 90 days or less, like,
yeah. So remember, this is from like when the appeal gets filed. And we can, before you had to wait 21 days to even find out what the scope of appeal was at the court. If we're, going to do like they're doing, we're going to have that decided right up front. What's wrong with the JO? Tell us what we're reviewing. And then it's a briefing schedule. So 30 days to the appellant to brief it. Then you give 30 days to the other side to brief it. So that's where you end up. And then, all right, so that's already 3 months pretty much. And then, and sometimes they like replies, they want an oral argument. We're offering to give oral argument. So that's another 30 days. So that's why it's like 4 months, in my opinion, is like the bare minimum. And it has nothing to do with how fast we're deciding it. It's what process has to happen in order to get to the point where we can make the decision. So 90 days is too short. The left-hand number where you see one number or the other, the left hand is what Alex was suggesting, and I'm just throwing in a higher number on the right. I haven't, like, it's just really hard to sit down and think, okay, we can look at a normal scheduling order at the court, but how to compress each of those deadlines is important, because those are the building blocks of, figuring out how long it's going to take. So I can give some more thought to this. I just threw these in because I was working on 10 million other things at the time. But I think that we need to give some thought to that. We don't need to, at this moment, pick a number. But I can give a little bit more thought to it and draft. They proposed like standing scheduling order that I think that we should have. But here's the problem. Things have gotten more complicated because now we're back to on the record review. And so now I have appellate rules that I have to now write a different, I had our supplemental thing, and now I got to add the on the record. So there are a lot of moving parts to bring this to a conclusion. So look, is it vital that these are the right numbers? No, but I would like them to be somewhat realistic and also
Yeah.
be able to demonstrate that we can reduce the numbers at the court. I mean, otherwise, what's the point, right?
Right. Brooke, can you edify those of us who didn't spend a lot of time in the court system, why you think 4 months is probably the minimum, even for a JO appeal?
Okay, yeah, so when it's filed, you'll want to give 30 days to write a brief explaining the appeal and what the issues are, and they argue and brief them. They say you're wrong because, and this is what the right answer is. And then, and these are what, these are kind of what the court time periods are. It's pretty typical. And then the other side gets the same opportunity after they get to read what the appeal is about to argue the other side of it. Well, no, the JO is correct because, or the permitting decision is correct because, that's how it. So, and then after at least a brief on both sides, sometimes they want oral argument or a site visit. So you have to schedule that. And then the next step is for us to write a decision. Once we have both briefs and oral argument, I mean, we can start writing, but you want to make sure that you have every step covered and some time to write it. So that's why I'm feeling like 4 months to get out a decision after briefing. That's a pretty tight schedule. I mean, it's not undoable or anything, but I would feel uncomfortable with less than that. Because you just don't necessarily know. Some people want to, I want to file a reply now because they said something wrong.
So, and that includes the sort of 21 days gained by requiring a statement of questions with the appeal.
Yeah,
Yeah.
So 30 days to get the first appeal brief, 60 days to get the other one. I mean, you could shorten the time frames, but people, lawyers are not going to be happy with that because 30 days is not a long time to get out a brief.
True, but are we
not catering to the lawyers?
right? Are we catering to the lawyers? Are we catering to, the citizenry that wants this process to be quicker, easier, more predictable, etc.?
I think we're catering to due process. That's the backstop.
Yeah.
That's, I mean, it's not, I'm not imposing this. I'm not trying to preferential anybody. It's about, the lawyers are the ones who are going to be like, no, you can't do this. It's too fast. That's deprivation of due process. We need our opportunity. That kind of thing. And the other thing is, and the other thing is that pro se's sometimes need time to be able to figure out what's an appeal brief. What do you mean we have to write something? How does that work? This is not something that pro se people have know what they're supposed to do necessarily.
Can we hear from board members on this? Sarah, do you have some thoughts?
I understand, the timelines, and I think this is the tricky thing that we've been talking about for the last few meetings. Because you don't want to get locked in. This will all be new to us. We don't know how much time we're going to need at different points for our volume of appeals is going to be. But I would hope that we could act more quickly. I think some of these timeframes are not necessarily going to make it faster to come to us. I think that's my initial reaction.
Kirsten?
So Brooke, I'm wondering on the JO appeal, if you ever came across information about processing times for the interval of time when the board was hearing appeals of JO decisions. And I'm wondering if I don't want to send you on a goose chase researching something that I think only happened for, a somewhat limited period of time, and it wasn't like a robust set of cases, just I think, but if that information is available, it might help inform this. And
Yeah,
I would be,
I don't think we have that.
okay, we don't.
I think it's only like processing times of, it's either like cases in general or permitting appeals. I don't think we have JO separated from the e-board stuff I've ever looked at.
Well, no, this was after the e-board. There was a period of time when the Natural Resources Board was hearing appeals of JOs.
Oh, okay. Yeah.
Yeah, and
It was-
Kirsten, you're talking about the reconsideration by the board.
Oh, yes, thank you for
and-
clarifying, Pete.
Okay,
Yes, that's
so it was
right.
a
It's not- it was
reconsideration
the-
rather than
the-
an appeal.
The board's
Oh, okay.
decision still went along to court. Thank you. That's
Mhm.
important, but it would, it would be somewhat similar in terms of the board taking it up, just.
I think it was a relatively small number. We could probably look
Yeah.
into that. Mhm.
Well, it might not be worth chasing
Well-
after very far. I mean, I don't think you need to do that, but, yeah, I guess, and I would be interpreting these timeframes as like an upper limit. I mean, that that you would meet or exceed this. So, I mean, I think the Act 250 appeals, like 180 days sounds probably like a good. I mean, I would hope again that we would often exceed that standard, but I think there could be more complex cases where you have to have maybe in some cases more than one hearing and a site visit, and it just takes time. So, I don't, these don't look totally unreasonable.
And let me suggest this. I'm going to go ahead. One of on my to-do list is to create the actual schedule, the proposed scheduling order that would be like the standing order you would have to deviate from if you wanted more time, kind of thing. Let me work on that, because that will be the building blocks of seeing how much time that we perhaps should give to the parties. This is not an issue of, I don't think, us and how much time we need necessarily. I'm more concerned about the parties' needs and timing that way. So I think that will help inform it. And if I can get any further data or information, I will, that if anything will help inform how we look at this.
Before I call on Annette, Alex, do you have any thoughts that you want to share? I know that the lower end of the ranges were your numbers, so any change of mind at all? Or are you still hoping that those are reasonable.
I take Brooke's point, but I also agree with Kirsten in that I think that we should strive for the lower numbers and have a range that gives us some flexibility when we hit the higher numbers and not declare defeat when that happens because of a complicated case. But, you know, I do think that we need to as a part of this, we should be upfront with the legislature that we are proposing, if we take appeals, to change the process by which appeals are heard by us so that it will not be the same as the court, and lawyers and parties should understand that there is a faster timeline and there's not going to be back and forth. There's going to be, you file your appeal and you indicate what the grounds for the appeal are, not just that you're appealing on day one. And then there's notification of interested parties, and they have a reasonable amount of time, perhaps 30 days, to you know, enter an appearance and make any supply any information. And then we're just going right to we're going right to a hearing. And the rest of the time is after the hearing for us to issue the decision. So that I think that's very different from the way the court works now, and that it's yeah, I just think we should be upfront that that's how we're going to shave time is by changing the process a bit. But in any case, yeah, I think the ranges are good, and like Kirsten, I'd like to strive to be on the low end, but understand that sometimes it'll be a bit more. And I think the ranges that are shown distinguish what should be a fairly straightforward decision on a JO versus what could be a much more complicated appeal on an actual permit appeal, right? Like JOs are not supposed to be as involved as a full-blown major project permit approval or denial. And I think what Brooke showed reflects that. So yeah, looks good to me.
And Sarah, are you comfortable?
Yeah, I'll echo. I'll just, for the sake of time, I think Alex said it all, is I'd be up for the lower end wherever possible.
Yeah. And I would just reiterate Alex's point about this, you know, presumably the whole point is that it's a different process. And I understand being concerned about due process, Brooke, but if everybody understands the rules, that's, you know, that's the process, and they can always appeal again to the higher power. So I don't think that we need to worry about due process if we don't make the lawyers happy. So Annette?
Hello. So I have a question and then a comment. You put in something about appeals of major and minor permits. I thought that minor permits were not appealable. Am I wrong?
You are right.
Thank you,
Okay.
Annette.
Well, they can be appealed if they're denied. The applicant has the option to appeal a denial, right?
Yes.
Okay, so that's an important additional point. I do have some context for thinking about these timeframes because in telecom cases at the PUC, there is in statute a 180-day shot clock. And there's prior to that a 60-day advance notice period. That 60 days is for municipalities to hold public hearings, give their recommendations and comments to the applicant. And often it's the towns don't have time that's not enough time for the towns to do what they need to do. Once it gets to the PUC has been sued 3 times over their shot clock. And the telecom industry is claiming there's a 150-day shot clock. But in any case, the 180 days, when there is a contested case, there's one hearing officer who does all these cases of the PUC, and he consistently has found that 180 days is simply not enough time to allow for due process. So what I'm thinking about, especially if a municipality denies a permit and the applicant appeals it, then depending on if the municipality wants to defend its denial, which my understanding is they don't have to, and then it would fall to neighbors to have to do it, which I find is a little bizarre. But if a municipality doesn't defend its or wants to defend its denial, uh, a lot of times boards have to meet and go into executive session and make decisions, and some towns only meet once a month. And anyway, once you involve a municipality in their participation in the system, it can become a much lengthier process. So I guess my one comment in terms of interacting with the legislature about this is that while you may have goals, I would be very reluctant to suggest you put them into statute. That just sets you up to get sued. The PUC has
Yeah.
not been successfully sued, but still, it's in federal court and it's just not fun. And so I think that those are my observations. And I have one other. Brooke talked about briefs and all that, but you're talking about cases where you're going to have witnesses. And one thing I'm not clear about is whether your process would be at the current practice of pre-filed testimony, or if there would be a hearing that would just have direct testimony, but it's been standard practice in the court and certainly at the PUC that everything is done with pre-filed testimony. It didn't used to be that way in Act 250, but it then became more that way. In the old days, it was reports by experts, but now everything seems to be pre-filed testimony, which takes more time. So if you're just going to go directly to a hearing, that's different. But the process and due process does take time. Okay, thank you.
Thank you, Annette. Yeah, the point about not wanting those to be in statute, I think I'll reiterate. They are goals.
Sure. How we doing on time?
Let's see. We're all right. You can keep going.
Okay. What I wanted to focus on now are the recommendations for to promote the efficient and effective adjudication of appeals. So this is, the laundry list of what else we can come up with. So let me bring up that part of the report where I have a paragraph on the ones that I've identified. Let me just go through them very quickly. Obviously the Rule 5 amendment, we all know about that. That's great. It's already being changed. Now, this is, I went and picked brains, and Jenny gave us some ideas on how to improve our program and our litigation. So one of the things that she wants to do, it is the current practice, but continue to endorse board counsel evaluating appeals for early motions to dismiss or for summary judgment as soon as we get the statement of questions, so that we can file a motion and dispose of the case or narrow the issues as quickly as possible right up front. Everyone okay with that?
Yeah.
Okay. Then we have clarified the Land Use Review Board's role in permitting appeals. And Jenny was suggesting we clarify the board's focus on overseeing the application of law, especially in cases where the dispute is between a permittee and project opponent. And then in jurisdictional opinion appeals, to clarify the intent to rely on the factual record to increase predictability of the board's role and for other parties. So this partially pertains to some of the guidance documents that I've been working on, but it's a good thing to get this information, in a written policy or guidance document, so that it's more helpful and people know what to expect in terms of our role. And the next two, we know we have to update our Act 250 rules, although there have been lots of guidance issued over the past decade. That's been very important in helping to implement, different changes to Act 250. We need to really bring them into the rulemaking arena because we're not allowed to issue guidance in lieu of doing proper rulemaking. So that that cleaning up of the housekeeping is really important, as well as for the board's rules of procedure, which they're being worked on anyway in relation to all of our other work. But I think it's important to articulate it here because we should also take a comprehensive look to make sure that not just the pieces and parts that we're working on, we do a comprehensive review. And then the development of policy directives, which provide sort of the framework for decision making, so that can be infused to our districts so that we can try to establish, or not try to improve and ensure consistency between our districts. And same thing about training for district commissioners. There's been a lot of changes and the interim guidance documents, and things are very up in the air, and it's really important for us to increase the training so that because Act 250 training has been, I won't say static, but we need more than just the fundamentals here because it's gotten complicated again, and we need to make sure that everyone is at the same place. Public outreach engagement, that I think pertains to lots of what we're doing already, but also to reach out in terms of the permitting audience, folks that will need to come to the program for permitting, try to encourage or help to better convey our program and that we are inclusive and want to reach out and help people to engage in the process or to communicate what their feelings are about it. And then lastly is the Permit Specialist Ombuds Office. I have a footnote in the study because I think it was really important to reference the necessary updates document, which I don't have it prettied up yet with the exact right title, but that was called out in the necessary updates document to provide additional support in the pre-application process, especially for applicants with less capacity and or fewer resources. This is what we heard at the Wood Products Manufacturing Study. We've heard it in Tier 3 as well. So while I don't have a baked cupcake for EJ at this point or permit specialist, I want to make sure that we do follow up on this. I think we should say that we're going to continue to study it and work on it. I don't think that we should just say, oh, let's think about it, because I think it is crucial and really important for all aspects of this program.
Brooke, on that one, there are the administration is undergoing this permit modernization task force-y kind of work. And they are talking about something that they're calling the big idea. And it might dovetail with this, such that perhaps we wouldn't necessarily have to do this within our program alone, but that it would be something more administration-wide. So I think maybe acknowledging that is occurring, and that, as a board, we should be engaged with that broader planning goal.
Great. No, that's terrific for sure. We're glad to hear that. Because, and I think that that was also the focus, you know, whether or not there were options discussed about whether it was a position within NRB at the time. So I think it's a really important piece, and I just wouldn't want to just drop it and have it fall to the side. Because I think now is the time to at least speak to the issue and make sure that we convey our support for that if that's what the board feels.
Sarah, you have a thought on that?
I have a thought on a couple of things here. I think after sitting through the hearing, in Randolph, the part about, the education outreach, and the training piece. The training piece, I think, we might do a better job of honing in and saying, with everything that's changing within the context of Act 250, we recognize that we need to do additional training. It's not that we're doing deficient training now or, our folks aren't well educated and well informed, but just on the cusp of going into all this, there's going to be a need for even more training. Let's not ding ourselves. I think we have really exceptional training that's going on right now. And I think there's been an increase of it, but I think we could frame that in a little bit more of a positive way of just saying, recognizing with all these changes, we recognize that we're going to need to do more. I think the other education outreach we've talked about, the board actually is tasked with coming up with a plan within the next year. And I think that might be nice to include and just say that we also recognize this, and this is something that we will be tackling within the next year, and that we'll try and dovetail these efforts in with those. I think just let's try and build ourselves up where we can. Thanks.
Sarah, were you referring to in the next year, the community engagement plan as part of the EJ law? Okay, it's a next year and a half, I would say. But, and Pete, is that your hand up?
Yeah, that's me.
Okay.
Let me just interrupt for a second, because I want to say, Sarah, if you have specific language like to explain that, it would be so helpful. I feel like I'm running on empty trying to write at this point. And it's like, okay, what did she say? What am I supposed to write down? So it would be really helpful. I don't, it can be half sentences, phrases, or whatever.
I was just gonna say, I appreciate what Sarah just said. I think that's great. The only addition, and Sarah, if you're working on language, I would just add staff in there too. Like there is a lot of changes and I think the way that it was written is just for just district commissioners, but I think the staff is really important in terms of making sure that they're up to speed on all the changes and that we've got resources and energies going in that direction will help on the appellate level too.
And
Pete-
Kirsten, you had your hand up. Did you
Oh, I
have?
was
something
gonna
to add?
mention the community engagement plan, but I also
Okay.
had the same thought as Sarah as far as, you know, we do training, but there is a need for increased training with all these changes. So I like the way it's being framed, and thanks everyone.
And Alex, your hand is now up.
So I think we're all on the same page about the permit specialist, that it was unfortunate it went away and it would be nice to have it back. I agree with Janet that, sorry, Brooke, I don't have the language to give you, but, just tweak to say that we would like to continue collaborating with other agencies on potential solutions and recognize that ANR already is, right? My understanding is that the permit navigator system is, I think, being taken down.
Yes, it is.
So maybe we could recognize that, and that the next evolution of what was permit specialists, then was permit navigators, we want to be involved. But
At
I'm
the
not sure that we
table.
I'm not sure we want to lead on that. I'm not sure that's really our role, given how many of the permits get issued by the Agency of Natural Resources, as we've discussed before. But the other thing I want to say, and this is a little existential, so sorry, but what I heard and in the tier 3 public engagement sessions over the last couple of weeks is a lot of frustration over the complexity of our application. And the belief on the part of many Vermonters that it's unapproachable, that the average Vermonter cannot fill out one of our applications. And I know partially that's perception. But here's the existential part. If we have to create a system with additional permit specialist staff to help someone fill out our application, rather than making our application more accessible to the average person, then we're moving in the wrong direction. Like, I think we should be working to simplify our processes, rather than creating a whole nother network of people that have to be there to help somebody interface with our processes. So that's not really a recommendation about about the report, Brooke. I just wanted to say that because I feel like I heard that loud and clear at literally every single one of the 4 public engagement sessions. And it's a problem, when somebody says, I can't fill out your application form. It's too complicated. I need to go hire a professional to do so.
Kirsten?
Sort of lost my train of thought.
Uh-oh.
Yeah, I heard that too. I guess I think it's important to also underscore that the role of the permit specialist or ombudsperson went beyond Act 250 and touched on elements of other state agency permitting and reviews that have a nexus to Act 250, and helped provide that broad guidance and support. So it's not just limited to being targeted at filling out an Act 250 application form. Something else, if it comes back to me, I'll put my
Okay.
hand up again.
Well, and I'll just come back to the permit modernization work that the administration is undergoing, and that, yeah, I think it mirrors what Alex just said, making it simpler. And the numbers of permits that we got some of us that were at this initial meeting got an overview of work that they did in 2018, I think it was, Pete. And the numbers of state permits involved in, I guess, new development, basically. I mean, it could be into the hundreds of permits and thousands and tens of thousands of permits issued by AOT and ANR and the entire state government on an annual basis. So it's looking at a very broad, it's taking a very broad approach, and it's looking at simplifying, making it more accessible to applicants and the public. Kirsten.
Yeah, so you touched on the very thing that I was wondering about, what's going on with that permit modernization. What, I now is probably not the right time, but I would love to know more about that. This is a topic that interests me greatly, and love to know what the big idea is that someone has come up with. And so maybe we can have a continued conversation about that at some point.
Yeah, we're going to learn about it as we participate in these meetings that the administration has set up. They're calling it, what are they calling it, Pete? The group, some sort of working group name. I
It's
can't remember right now.
Yeah, task force of some sort, but yeah, we had our initial
Not
one, as
task force.
Janet said, and then we've got another one tomorrow, so we should learn a little bit more by then too.
Yeah,
But happy to keep people appraised on it.
yeah. So,
Take
yeah.
ideas.
And, we could maybe, when it makes sense, rotate different people through.
Yes.
The administration asked for names, and, they wanted point people from each program or agency. And, I wasn't quite sure who would be the best names to put forward. So initially I just put the leadership team's names forward. So, but we'll keep you apprised.
Accelerated Permitting Modernization Initiative is what it's called.
Right, but then they called the group something, something different, but that's okay.
Yes.
We're off into a rabbit hole here. Brooke, do you have anything else to get our feedback on before ending today?
No, I think I'm good. I think
Okay,
I'm good.
great. So
Thank
we
you.
have a break scheduled here, 10 minutes. So perhaps we can come back at 2:20. Give people a break. Pete, can you put up the little sign for us? Thank you. Okay. I think we are all back. Yes. So let's turn it over to a discussion of the Tier 1A guidelines as they've been drafted. And Sarah, I guess I'll ask if you have particular areas of input that you would like to receive from board members on this.
Happy to throw it up on the screen and go through it generally, take specific comments. Just looking to, we have a January 1st deadline on this to look to advance. I think what was provided had all of the things that we discussed and agreed upon the last time at the beginning of October. Changes were made to try and clarify and simplify wherever possible. It still needs additional legal vetting. I'm happy to go through some of the highlights of the changes and throw it up on screen unless anybody has anything that they'd like me to start with.
Let me just ask first if there are any general impressions or questions from the board on this, from board members. Are there any? Okay. And okay, go ahead, Sarah, then maybe give an overview of what's changed and if you can, where you'd like to focus discussion.
All right. So I think first and foremost, and hopefully everybody can see that. Do you need me to make it any bigger or is this okay size?
Looks
Okay.
good to me.
All right. So I think where I'd like to focus some of the discussion, I think generally, let me get down to the pre-application. So where we left things on the pre-application is it is going to be a mirror of the application process. It is going to be something that will have an application form. We do not have any forms created yet. That is something that's going to happen after January 1st, just looking to prioritize our resources. And technically you won't have anybody that can apply for a Tier 1A until after their future land use map is approved, which will probably be late spring at the earliest. And given where our staffing's at and capacity is, we aren't going to be creating forums until probably late winter on this. But there will be a separate Tier 1A pre-application form that will mimic the actual application form. This is free of charge. People can come through it as many times as they want. They can do an informal meeting with us too. But I think just to generally sort of bring this up as a discussion point again, I think what I had heard in some of the previous discussions was a more simplified pre-application process. The con with that is then we have 45 days from the actual submittal of the application to do findings. And we are really trying to hopefully inform the applicant municipalities of any concerns that other partner agencies within the state might have as soon as possible in the process. And this seemed to be a fair way of doing it. So the other thing that's changed to the pre-application process is we are going down to one reviewer, similar to the process that we have for regional plan review, because more than one board reviewer could generate a subcommittee. We are welcoming other reviewers, but there will be one board lead on this as opposed to 2 or 3 board members. You could have other board member involvement informally, but just looking to mimic what we've done with regional guidance and concerns about open meetings and what have you, and making this even more of a formal process.
Sarah,
Yes.
but this still says will consist of at least 2 board members at the top of the page there.
Okay, maybe I made the change in the actual application
And not
as
the
opposed to the
pre-application?
pre-application. Yeah.
Oh, okay. So probably you should do it in both places, just.
Yep.
Okay.
There's a typo, Sarah, in that second line of the
Yeah,
top
they are.
paragraph.
The
Yeah.
errant are.
Second line, oh yeah.
Kirsten, do you have a comment, question?
Well, yeah, could you just walk me through, just so I'm really clear on how it's envisioned that this would work in terms of the role of the whole board in the pre-application process?
Sure. So in statute, the pre-application does not need to be the board. It's not it is not the regional plan pre-application. It does not need to be a board meeting. As a matter of fact, it talks about having Act 250 staff. So I think what we've tried to do is make sure that this is going to be an open meeting, that everyone is welcome, we're as transparent as possible. However, this pre-application does not need the blessing of the board in the way that a regional plan pre-application does. Does that explain it well enough, Kirsten?
Yes, so the pre-application meeting would be attended by just the one board designee and not the full board?
It could be the full board, but let me sort of fast forward down to the end of the pre-application response. What will happen is after we have had this meeting and the reviewers have sort of bandied together their set of feedback heard from other agencies, we will give it to the board in an open meeting to make sure that you are on board with what our response is. So rather than having the full board participating necessarily in the pre-application meeting, and again, this is going to hopefully be rather informal, we could have several of them, is that we are going to make sure that this gets vetted by the board at the end before it goes back to the applicant. Ism tight.
So,
Go ahead.
so just so I'm crystal clear, because this would be reported out to the full board, is it the full board that's making the response? Because it looks like that's the case here. So it's the board's response sent to the municipality.
Yes.
So the full board has that responsibility.
That I think was the way of trying to bring it back to the board for board ownership in it. Is that the whole board need not be involved, all of you, in the reiterative pre-application process, but that before all the sort of some parts are gathered, that they're vetted with the board before it goes back to the municipality. Any other questions on the pre-application process? All right, I'm going,
Sarah, I would only
Yes.
note, since we're on it, that the notice list, instead of notifying abutting regional planning commission chairs, I would notice the directors.
I'm pretty sure this is from statute, but
Oh, it
we
is?
could,
Maybe I would say chairs and directors, because there's probably some regional planning commission chairs that will have no idea what it's about, and, so
understood.
I would include directors in that list. And then,
Well, you do have the regional planning commission down here, and usually the
Yes.
executive director is
Yes.
the,
okay. And that's the other thing I was gonna say is, the Regional Planning Commission and the Regional Development Corporation, I guess I would put those on one line. Some of them are combined, some aren't. And
Yep.
that we are referring to the municipalities, '(S), Y'(S), particular Regional Planning Commission and Regional Development Corporation. So add the word municipality to that, and maybe, yeah. And those are the abutting Regional Planning Commission chairs. I still think it needs to go to the abutting Regional Planning Commission directors. Aside from what statute is telling us, yeah, we can send it to the chairs, but that might not get us anywhere. Brooke,
so I think just before I move on to that is, I'll just to clarify, this all will be the municipalities requirement to notify. So we can ask the municipalities to do this, but this will not be us doing the notifying.
Correct.
Okay.
Correct. Brooke,
Yeah, so on the notice, are you gonna like specify how notice has to be effectuated? Like by email or, you know, that kind of thing?
The thing that I'll come back to is on the pre-application, there is absolutely no notice requirement in statute. We're advising municipalities that we would like them to notify the same people that they're going to notify with the application, so that we can harvest as much information from these different agencies, RPCs, about what their concerns might be as early on in the process. It could be that we get a municipality that comes in for a pre-application, gets feedback, and then decides not to proceed. So although we feel strongly this is not legally required at this point, once we get into the actual application process, we specifically state the portion in state statute that says the hows, the whys, just those details, Brooke.
So should we then be using like they will do this or they're encouraged to, or anyway,
So
just
it's
wondering, I mean,
it's our pre-application process. And so we're structuring it to say that this is something that we expect municipalities to do, to notify. I think that's part of the concept of the pre-application process that we're developing.
and just one other thing in the next, can you pull down to number 3 on comments?
Yep.
It says all those wishing to comment. Who are we talking about? The people that you just mentioned above, or
It's
anybody
everyone.
in the public, or?
Anyone
Okay.
in the public and the above, all are welcome.
Did we put a like 2 days before, whatever the deadline? I mean, it says before, but
So
you
they could
wanna-
actually come to the
you-
pre-application meeting and have
oh,
comments.
itself. Okay. Gotcha.
Any other questions on pre-application? I think some of these questions might be addressed through the application process, but I'm just going to move on to try and get into the application process. And so the application process, where they're actually asking for a determination of compliance from us. And sorry, I'm noticing some of my font here with I'm not quite sure what happened with the conversion to PDF, but I have some other things to clean up. So the maps of the proposed tier 1A status areas, these are generally things that we want to see, but these are going to be portrayed digitally through our portal as well. So similarly to the regional plan viewer, we're going to have something similar with this. But we do want to make sure that a municipality provides us with things showing their natural features and parks, any historic preservation districts, water and wastewater, and those might be separate. I think one of the things that we learned from some of our feedback at the RPC level is not all municipalities have their water, wastewater available in GIS readily. So I think
so
here we're
Sarah,
taking, yes.
on this, we're going to have a meeting with Josh and Eric.
Yes.
And so we'll have to pull you in on that because some of this information would be new. We haven't forewarned them that there might be these separate digital submissions from applicants other than the tier 1A area, and that the map viewer strives to have all that other data in there. So it has the natural features that you know, that A&R, for instance, has identified. It has mapped wastewater areas that are digitally available, and it has, actually, I can't remember if it has historic districts. Does anyone remember? I think it might.
I
So
think it does.
if the municipality has data that is different from what is already available via VCGI, and it needs to be submitted along with the Tier 1A map, we just need to be very clear about that, and we need to talk to them about how that should be indicated on the submission. So just stick a pin in that, and let's circle back on it.
Yeah. I think the other thing to put out there for thought is, since we might be trying to accommodate a variety of municipalities, some that might not have fully GIS data, for instance, on their water and wastewater service areas or a historic preservation district, is this will provide not necessarily an equal playing field if some of it is digitally represented online in the GIS portal and some of it isn't. And so we could just nix the idea of having it be represented in the portal and just, as this has in here, say that they have to provide separate PDF maps to us. So just when you have people that are doing hybrid approaches, or some but not all, just trying to make sure that we're having a level playing field. So just a thought for future
So
discussion.
let's you and I talk about that in more detail rather than having the whole board talk about it now, unless particular board members have input that they want to give on that, those sort of technical details about the digital GIS submissions.
All right, I think I'm hearing that it's going to be you and I, Janet, so I'll keep
Okay.
on moving. So just another, so once we get into the actual application process, a lot of this is specified in Title 10, 6034. And I think one of the things, flood hazard areas, I tried to clean it up. So there's the flood hazard area and river corridors. These are two distinct portions of it. But a lot of this is specifically from statute. There is the portion about form massing, etc., which we decided to try and create a narrative around. But the Unified Development Bylaw or zoning and subdivision regulations, that's pretty straightforward. Sorry, I pushed down too far. The form and scale continues on with the narrative. And what I tried to do within this, and I'll just describe E and then I'll stop, and I see Brooke has her hand up, is talk about how the regulations further smart growth principles. And the wording on this is a little bit tricky because it's the regulations creating the future growth. So in talking about sort of the aspirational of how these things are going to create compact settlement, yes, the wording absolutely needs to be in the regulations, but just recognizing that the regulations don't create the development. They create the structure for the development in the future. So that's why some of these are phrased to the future, if you would. And again, going along with the narrative that was decided, trying to clean up a little bit of language to be as straightforward as possible. But again, telling a municipality to tell us how they are meeting these smart growth aspirational principles. Brooke.
Yeah, I was just not enamored with the use of the word stronger when we're talking about consistent with or stronger than an existing regulation. Is there a better term we could use, like more restrictive or protective, or?
Which line are you at?
It's in a couple spots on the river corridors and flood hazard section where it's like in number 2 on page 7.
Consistent with or stronger than.
Or stronger than, is that?
Maybe consistent with or maybe meeting minimum standards of, or something like that.
Meeting or exceeding.
this,
Yep.
the standards of.
Okay,
See,
got
Sarah's,
it.
and then if I can piggyback onto that, I find it cumbersome or awkward to use PDF as a word in the sentence here. And I think, or in these paragraphs, and instead, I think we can refer to the evidence shall be submitted pursuant to 2.06B1, which is referring them back to the FTP site and how to submit PDFs. So the narratives and the evidence here should be submitted pursuant to 2.006B1. And that's the river corridor paragraph, the unified bylaw paragraph, wherever
do
you
a-
use the
I
PDF
can do a
thing.
search and destroy. Yep,
Okay.
good. Thank you. Ken Baldwin?
We've got a comment from the public. Thomas?
Hi, this goes back to Brooke's comment on the word stronger than. That's actually in the statute in 6034.
All right. There you go, Brooks.
Oops.
Good one. I thought it's not a term that I usually use and I wasn't quite sure, but good catch.
I'll
I
keep it
guess
with the
there was a
statutory
reason it was there.
language.
Huh.
Sorry, Ledge
right.
Council.
Thank you,
Any other-
Thomas.
Before we go on any further, any other thoughts on form and scale?
Well,
All
I'm
right.
wondering if you can explain, has any of this materially changed since we reviewed it last time?
No.
Okay. It's just been quite a while, but in looking at it, it seems straightforward.
Yep. I think the thing that I highlighted was the trying to pull out within the river corridor and the floodplain and sort of separate that out. But most of this has not changed. I think we have tried to clarify some of the wording here and there. Historic and cultural resources has not changed. Natural communities, again, hopefully we're going to have a model bylaw that we can refer to as opposed to the cumbersome language that we have here. Continuing to work through with A&R on G and what this might want to become, but this has not substantially changed since the last you saw it, nor has wastewater. Municipal resolution items. I think this goes to the staffing availability, qualifications, availability of municipal league council and enforcement budget. There was, I think, some comments about maybe utilizing this staffing ability to sort of get into the weeds a little bit more about the administration and enforcement piece. However, if you come back to what we can require in the vetting of an applicant for receiving tier 1A, it's pretty clearly spelled out in 6034, and I'm not sure how broadly that we can construe that. And I think on the administration enforcement piece, which the board previously discussed, we are going to be asking for some statutory change to the language around that to help clarify that instead.
Sarah, before you move on,
Yes.
can you scroll back up
Yes.
just a little bit to the top of the page? Those two bulleted lit items should begin with the capital A rather than the little a. And
Okay.
then I sort of felt like the fee being the last item gets a little lost behind the extensiveness of some of the previous, and I wonder if we can move it up to the beginning somewhere. Does that
I
make,
chose
I don't
to
know if
put
anybody,
it in the same spot as the regional plans, but I'm happy to move it. Lesson learned on regional plans, we can move the fee up. Okay, that can
I
maybe
think
be A
it's
instead of
just
J.
because some of the intervening sections just go on for pages, and I don't know, just feels like it's so brief. Let's just put it up front so it doesn't get lost.
Got it. I'm going to move into application review, and this is where we do have that one board member will coordinate. Not much has changed within this section. And yes, this wacky timetable is prescribed by statute. I worry about trying to define it more and making it more burdensome.
So
But it's pretty,
if we have to make a decision within 45 days of the application, we can't give ourselves 45 days to hold the hearing. Right? And didn't we point this out? And isn't it a problem in the way that statute is constructed here?
right. And so you're right. We have to hold the public hearing and do findings within 45 days. And we're just recognizing there's a 45-day time clock here, but we aren't giving it. The next part is at least 35 days prior to the public hearing, the board and the relevant RPC have to post notice of the hearing. So it's
So
going to be
maybe
like
can't
this
we do it-
10-day window.
Yeah.
It's going to be so tight. I worry
we
about
say-
prescribing it.
Can we say 40 days or something so that we have a few days on the other end?
I understand what you're saying. However, I worry we're talking about there's like a 10-day window at max
Yeah, I know.
to have the hearing and right. Let me
You can keep going. We can keep
Yeah.
thinking about it.
Can I jump in with a question about this section?
Yeah.
So Sarah, under paragraph 2.202, application review, which identifies that the board would assign one board member to coordinate the application review with the Tier 1A reviewers that conducted the pre-application review. Wouldn't this also be coordinating the board's review to coordinate the application review with those Tier 1A reviewers and the board itself?
So the board will assign one board member to coordinate the the application review. I took that sentence to mean that one board member is coordinating the board's review, as well as also with the Tier 1A reviewers. But we can perhaps specify that. Better?
Okay, that wasn't quite how my brain interpreted it initially, but I could see what you're saying now. To coordinate the application review, including coordinating with the Tier 1A reviewers. Yeah. To coordinate the board's application review. I just wanted to be clear that that lead designee is coordinating, the board's review,
Right.
but
I think you're right. The wording maybe could be coordinate the board's application review for the board. Might be a little bit redundant, but it might be clearer. I'll play with the wording on that. 10 Baldwin.
Yeah, we've got another comment from Thomas.
When you're discussing the timing, I believe that the statute requires that there be notices of the hearing in newspapers of general circulation or public record, or whatever the timing is, 15 and 30 days in advance of the meeting. So that will also affect your timing. And the day that you negotiate with the regional planning commission or the municipality, sorry, in this case, to actually hold the meeting. A lot of, Chittenden County area, a lot of the public notices are in 7 days a weekly.
Did we lose audio on 10 Baldwin? Or
What
Was
was
there
that,
more?
sir?
was there any more?
Did you want to?
No, I
No.
wasn't sure
that-
if you guys cut
yeah.
out. Okay, so this next portion, absolutely, and I think it speaks to, I think Brooke had the question before about how is notice supposed to be provided, and so we're referencing back to 10 VSA here. And again, it's interesting because the only thing that the board needs to do in the posting and the outreach requirements is this portion within the 35 days, the board and the relevant RPC will post notice, and then the rest is on the onus of the municipality. But Brooke?
And I'm trying to understand the sentence that begins on the bottom of page 10 and goes to 11 about, is that 7-day thing? Are we just making that number up or?
No, it's in statute and,
Is it?
yeah, and so it requires the municipality to send notice to the board that it has sent notice. And this was the case for the regional plan applications as well. And we put in our guidance on that if the municipality in this case forgot to send the email to the board, we're not going to make it reschedule everything. As long as it can show that it, that it put notice out as required by 10 VSA 6034. So that's what the footnote is, though I think it's a little bit awkwardly worded. But that's what was meant by that. Does that help?
Yeah, it does. I was just trying to figure out logistically.
Yeah.
What
It's
do
a little
we get?
convoluted.
I mean, when do we find out that nobody was told?
Right.
If
Right.
it's only 7 days ahead, and then how do we timely cancel something if,
Right.
others are expecting it and all
Right.
that, so.
Especially when we barely have any time. And I'm a little, as I read the last sentence of this paragraph, Sarah, do we have the statutory authority to reschedule if they've submitted us an application and we have to make a determination within 45 days? Do we need to make a determination do we need to make a negative determination and have them start over because of this?
So the flaw is caused by the municipality, which is our applicant, and much the way in any other sort of development review proceeding where an applicant can request an extension, I think an applicant would be completely on board with us in terms of a delay as opposed to a negative determination. I think we can, with legal, create some more language around that, that the applicant would have to consent to this time extension, but I think a municipality would very much want to take an extension as opposed to getting a negative determination for an
Yeah.
error on their part. Alex?
Yeah.
Can you just remind me where the 45-day clock is? I'm sorry, I can't put my finger on it in Act 181 or in statute. I see the 35-day notice and hearing within 45 days.
It's in 10 VSA 6034. Is it B or C?
I think it's
I don't have it right in front of me, but
134
See,
C, I
like
think.
that.
Yeah, C.
Okay, thank you.
thank you guys.
I think.
I'm just going to, so I don't cut into tier 3 time, I'm just going to quickly move through. Not much has changed in this since the last time you saw it. There's the hearing process, scope of review, recommended determination, board review of recommended determination, affirmative, negative. And then I just wanted to quickly go over this review of status. Again, nothing has really changed within this, other than I'll just keep this fresh in people's minds of this is something where we can request to have a municipality come back. They have to come back at least every 4 years for a check-in. The tier 1A proceeds in perpetuity until we rescind. Trying to spell out what would happen under review of status. Again, this has not changed, but just saying that if we request a review of status, we're giving that municipality ample time to assemble the information and come in. This has not changed since the last time you saw it. We are going to conduct this as a hearing process, although we're not required to, because if we modify or rescind tier 1A determination, we're best to perhaps have on the record. The scope of review for that, and then also issuing a determination at that time that we're coming in and reviewing, and we can prescribe corrective action or negative determination and remove the tier 1A. And again, it hasn't changed since the last time. I'm going to stop sharing unless Janet, is there anything that you want me to go back to?
So I was wrong, Alex, in response to your question. It is 6034A2 is the reference to the board having to make a decision within 45 days after the application is received.
That's
So,
super helpful. Thank you,
um,
Janet. I wasn't seeing it where I
Yeah.
was previously pointed to, and now I do.
Yeah.
Thank you.
Yeah, so that's where it is.
So I think it was helpful that in the interim, since we last saw this, we had the conversation around administration and enforcement. I think there's some modifications to be requested with the legislature there. But I think in terms of the application, I'm feeling like we're honing in, but I very much appreciate questions, comments, and some of the cleanup. We'll continue with the cleanup. I'm hopefully going to bring this back in another week or two's time. But any other questions or comments before I turn it over to tier 3? Right, well, thank you,
Sarah,
guys.
just the comment that I'm not sure it seems like you're done, right? Like what else needs to happen with this other than legal review and tidy up?
Yeah, that's basically it. I think we'd hope for the end of the month on it, by November 24th. So I was hoping to at least put it into your packet for just a sort of conversation, the way that Brooke, I think, has really sort of set the standard for us in terms of like, hey, any comments back to me before this comes to you for a decision. I don't know where we're at in terms of legal staffing and timelines, but it is my hope still to bring it to you for a decision point on November 24th, because after that, I'm hitting the ground running, and my December is going to be CCRPC plan. We had the hearing or the public meeting on December 1st, and then have to issue back to them by the 21st. And we have a January 1st deadline on this. So that is the goal. So I'll keep you guys informed, and hopefully we'll keep that schedule.
Yeah,
Thank
and
you.
all I'm advocating for is I don't need to see it twice. Like you can just bring it, for my purposes, you can bring back the final version with an agenda item that says, consideration or adoption of tier 1A guidelines, and we can do it I can do it in one meeting. Unless legal explodes this thing somehow and blows it up. But otherwise, I don't need you to come back and say, what do you think? And now we'll finalize it. Like that was today. So I'm good.
Thank you.
Kirsten, do you have comment?
Mhm. I just kind of wanted to put a footnote on the topic of the previously issued Act 250 permits. I think that this application guideline doesn't put forward that the municipality would provide, its own inventory of what those permits are. And I know this is perhaps a moving target, so I don't think we necessarily need to sort of nail down something within this now, but maybe with, as this moves to final or in future iterations of it, that kind of information could be something that we would ask the municipality to provide alongside its information about municipal capacity. Because the municipal capacity might, if they're looking to assume responsibility for a handful of permits versus dozens, it would be, different, right? What that responsibility would be. So just kind of, it's more of like a comment, but if Sarah wants.
Go ahead,
So,
Sarah.
I think that's just there's a two-parter to that. So the first is if you read 24 VSA 4460 G and H, that prescribes what a municipality has to do. And we don't necessarily have a role in how they choose to administer Act 250 aside for we can claw it back. So we're developing some tips and some FAQs around that. So best practices for municipalities, that will be a separate document, and some recommendations as to how they should, but at the end of the day, the liability is theirs. If they are ineffective or administer it in a way, the legal liability is with them. We can claw it back. We can take tier 1 back. That's sort of our remedy for it. But I think that's where we're really, the second part of that is we're really trying to create a robust pre-application process, is so that when people come in through that pre-application, we'll hopefully be able to give them a list of Act 250 permits so that they know coming in before they've paid the application fee and really full committed is, you're looking at, here's the list of however many Act 250s. What do you think? And have that sort of, it might be a reiterative process. It's a free process. We can sit down with them, and there might be a few that say, this is too much for me now. My hope is that we are going to be receiving some legislative clarification on this so that people are not overwhelmed by that. But you're right, Kirsten, until that happens, we want to make sure that that pre-application process is a real time to sit down with applicants and go over exactly what they're going into, what those expectations and FAQs are, and make sure before they go too far down the pipeline that they're prepared for it. Absolutely.
And the draft FAQs, that's something you envision bringing back to the board?
Yes.
Yeah, I
She
think it's
does.
critically important
answer
that the list be verified, right? That it's, well, as you just indicated, Sarah, that it's very clearly understood. Here's the breadth of them, here's the exact ones, etc. So I'll stay tuned. Thank you.
Okay, Alex, tier 3 update.
Yeah, so as you all know, the last 2 weeks have included 4 public engagement sessions on the first draft, or it's actually draft 2, but the first public draft of the tier 3 rules. And so we met in Morrisville on October 21st, Rutland on the 22nd, and then last week in Newport and Windsor on the 28th and 29th. And each of you accompanied me to one of those. So all 4 of you got to hear from the public in one of those venues. And the recordings are available on our website. So if you would like to watch the meetings that you were not in attendance for, you can do that, and you can speed up the playback so it takes less time while still understanding what people are saying. I do not have the written summaries done for those meetings, but I hope to do that this week and circulate them, and they will go up on the website when our web maven returns to her office. That would be Maddie. So in a couple weeks. I just wanted to share with you the takeaways that I had, and then if any of you had some different ones, you know, happy to hear them. So one of the big takeaways that I think was expressed at all 4 of these sessions was really strong concern about the expansion of Act 250 jurisdiction in these tier 3 areas, given concerns that people have about cost, time, and process of our application system. I think that there was a desire, sort of dovetailing with that concern, to make our application easier, shorter, and less costly to complete. I noted several folks said that the tier 3 jurisdiction is going to capture construction done by just, you know, regular Vermonters, non-developers, people who are just living their lives on their 5-acre or 12-acre parcel, and happen to have some tier 3 area associated with their property, and they want to do something that's not exempt, and so they will be in Act 250. So again, concern about the process and a desire to make it a process that a layperson can accomplish at least for simple projects, without having to hire additional professionals, just to understand and complete the application. And so there was some discussion at one of the meetings about, is there a way to do a more simplified application, for very small projects? Or should we be talking about additional exemptions or wider exemptions within the Tier 3 rules so as not to capture those very small projects? There was a comment at a number of meetings. These takeaways I'm sharing with you are just the ones I heard at multiple meetings. There was a comment about providing more notice to affected landowners as well as municipalities. And so figuring out a way to do that, which is consistent with our statutory requirement from Act 181 to educate municipalities and landowners that have Tier 3 areas. That's something that we need to do more of, and figure out the best ways to do that. There were several comments about providing summaries, county and municipal summaries of Tier 3 land area in each county and each municipality, with a breakout of how much of that is on private land versus how much is on public or privately conserved lands. That should be fairly straightforward for me to do once we have the Tier 3 layer cleaned up a bit. There was concern at all of the meetings about trails. I think that the trails organizations got the word out about these meetings, just like the realtor organizations did. And there was an acknowledgement that the draft needs to be refined to deal with jurisdiction of trails, and that the current draft talks about jurisdiction triggering for more than 100 feet of new trails. And folks, said that's probably not the right number and we need to think about that some more. And then finally, there were several comments at several meetings about clarifying Tier 3 jurisdiction for projects that are already underway when December 31st of 2026 happens. So how will we treat projects that are already substantially complete? How do we treat projects that already have an Act 250 permit, but may trigger the need for an amendment or something like that, based on a specific Tier 3 area? Projects that have other state permits in hand, like a state water wastewater permit, maybe a VTrans access permit, maybe local level permits, but didn't require an Act 250 permit and now will under Tier 3, and whether there's any sort of pre-existing status that we want to grant as a part of the rules. So there's a variety of sort of, pre-existing situations that the rules should address so people can understand whether they will trigger Act 250 for a project that's already in the planning phases or partially complete. Yeah, and there was also comments about the equity between municipalities and the recognition that not all municipalities will have future land use areas that enable potential Tier 1 consideration in the future. And so if that's one of our mechanisms to provide equity, to exclude those future land use areas that are designed for potential Tier 1 designation from the Tier 3 rules, if that's one of our equity measures, we need to understand some municipalities won't have them. So we need to, be cognizant of that. So those are just the takeaways that I had or heard at multiple meetings. Happy to take questions or hear from you on what you heard.
Kirsten, you have your hand up.
Oh, yeah, just kind of a continuation of the reflection insofar as the Newport meeting that I was able to attend. Alex, you may recall, we also heard from an attorney who brought up the issue of that permit specialists are no longer available to assist the public and applicants. And this was seen as, a concern. And the person was underscoring, the value of the permit specialist. So Alex and I shared that this was something the board was aware of and was going to be continuing to advocate for ombudsperson office, some form of that kind of support for applicants. Also, you mentioned cost, but a little bit more specifically, there was a member of the public who wanted a better understanding of what the specific application fee might be for a single family home. for instance, for a family member. And we do currently have within the statute a situation where sometimes the fee collected is based on or includes consideration of the cost, the estimated construction cost of the home. Sometimes it's only the per lot fee. So I just, kind of wanted to put a pin in that. And the other thing is, Alex, I think you said that trails were brought up at all 4 meetings. I don't recall hearing that specific item mentioned in Newport. I might not be remembering correctly, but it sounds like it was well mentioned at the other meetings. So, yeah, it was, I thought the Newport meeting, from my perspective, was well attended and a lot of interest. And I think we just need to continue to be mindful of how best to engage all the stakeholders and the public. And Alex made known that there will be another public engagement opportunity in the spring. And maybe we can do something before the spring just to kind of help people more directly remain aware of the work that's underway.
Thank you, Kirsten. I just wanted to touch on the point you brought up, Alex, about previously permitted and projects in different stages of development, I guess. And it seems to me, I don't know why we would treat this any differently than, a zoning permit application. And when a permit application is made, it is reviewed under the laws that are in effect at the time that the application is deemed complete, basically. And if a permit is issued, doesn't matter whether law changes. You don't make somebody come back in and get a new zoning permit, So I kind of would think that we would go by the same rules in that sense there. Somebody prepares an application based on the laws in effect at that time, and it is reviewed under the laws in effect on that date, and a permit is issued based on that. And we can't make people come back and get new permits because there's now tier 3. So
And that speaks to our Act 250 permits specifically, someone who has received an Act 250 permit and is wondering whether this new level of jurisdiction will trigger something additional, and you're advocating that it would not for
Right.
that project. Yeah.
Right.
I think
But if an amendment, if somebody comes forth with an amended project, they're reconfiguring everything, then they need to present a new application, and if tier 3 is in effect at the time of their application, then yes, it would be triggered. But
Yeah,
sorry.
gotcha.
Yeah, I interrupted you.
Well, I was just going to say, I think that's helpful. I think the example that some folks gave that struck more of a chord in my mind was, I'm planning a project in next year, in 2026, I'm doing project planning, and this doesn't go into effect until the end of 2026, essentially 2027. So, what happens if I have a permit from VTrans to put in a driveway and I put it in, and I have a permit from A&R for a water wastewater system and I haven't put that in yet, and I'm ready to go to construction in 2027, and I'm not jurisdictional now, but I have a tier 3 area. Am I jurisdictional in 2027? I think the answer is, yes, unless our
Yes.
draft rules say something otherwise. And the variants of that are, I have the driveway in, but I don't have anything else. Or I have the driveway in and I put my septic system in the ground, but I don't have the house, which is sitting right next door and now is jurisdictional in 2027. Do I still need a permit? Or
Yeah.
I've
Yeah.
poured a foundation in 2026 and I haven't built the house yet, but I put the foundation in and it's settling over the winter. I'm going to build the house next year. Is that true? So there are just some, examples that I think the draft rule ought to clearly address.
Yeah. Yeah. And then the other thing that I wanted to say before moving on to Brooke is, I mean, I only went to one of the meetings, and notification of where tier 3 falls on somebody's property. There's a push for the board to notify every landowner in the state who may be affected. And there was a push from the Rural Caucus on this a few weeks back. And when I said I didn't think we would be doing that, and and got the question repeatedly, why not? Why can't you do that? I just said, because we don't have the budget. I mean, I think it would be something that requires, it's not as easy as just that. It's going to require money and time and effort to do that. So it looks like, though I haven't read it yet, that we got, at least I got an email today from Laura Sibilia about proposed legislation that would require that the board make this notification. I would hope that there's some money in there that would help the board do so if it does gain legislative approval. Brooke.
Yeah, I want to go back to the conversation that Alex was just having about, and you were about vested rights. That is not the kind of thing that I would expect to see in a rule. That's case law, and it's very fact specific, but typically, if your application is in, there's interim zoning issues, when zoning changes and all that stuff, but basically it's like, do you get through the door with a deemed complete application? You can't put in, a placeholder that is not really complete or that kind of thing. And that is your claim to whatever the existing law is if it changes and it's not in your favor. But we also have case law that says if the law changes in your favor, you get to take advantage of that as opposed to the prior law. If you're, in process of getting decided upon. So I don't think we should be getting in the weeds on that. I think that, we let common law govern. And there is plenty of Act 250 law. It's in our e-notes on vested rights as well. So I just wouldn't want to get
Brooke.
too much of a Pandora's box on it.
Yeah, thank you. Pete?
Yeah, I did just circulate that legislation to the board so you're aware of it, and I just highlight that they did have 20,000 in there for publication and notice pieces, whether that's sufficient or whatnot, but at any rate, that's in there.
Thanks.
Well, and to speak to that, Jan and I have talked about this, but we won't know what the magnitude of that sort of direct notification to landowners would entail until the tier 3 areas are further refined. And it's only then that I'll be able to merge that with the parcel database and say their tier 3 areas appear to, on 2,000 parcels or 25,000 parcels. We can't do that yet, but hopefully once the refinement process happens this fall, we'll be able to do that, and I can bring it back to the board and say, here are some options for getting the word out to people a little more directly and what it might cost.
And
Not
I think
to-
we should
yeah.
review that proposed legislation and follow it closely, Pete.
Yep.
Because yeah, we should.
Yeah.
And we
on
should
my list.
understand that parcel data, it varies. The accuracy of it varies. The currency, or whether it's current and up to date, varies. We can assume that the Vermont, the statewide Vermont parcel data layer is as good as it gets, but there are some rat's nests in every little town, and there, there's no way that we can get 100% notification out. It's just not possible, understanding the problems with the data. And so I think, I think that's something to look at in the legislation that's being proposed and whether it recognizes that fact. So, Kirsten.
Yeah,
Yes.
can I follow up on that real quick?
Sure. Yeah.
Just keep it flow. So, and going to what Alex was saying before as well, I think that legislation involves notice for tier 2 road construction jurisdiction as well, which also has that same kind of chicken and egg conundrum that Alex was talking about, not knowing who's going to be constructing something that would potentially trigger.
Yeah, I mean, that you might as well send a notice to every single landowner in the state about. Kirsten?
No, I was also going to mention the challenge of the accuracy of the landowner data set. And maybe, a solution could be to send out a notice to all landowners concurrent with tax billing or something. Like take advantage of some other mass mailing that's going out if this bill advances, or I guess
Yeah,
we'll see.
though I think you will find that most municipalities will resist that. They won't
Well-
want to enclose something from the Land Use Review Board in their tax bill. But just keep that in mind.
Yeah, I understand. The
Yeah.
other thing I wanted to say about the tier, since we're talking about the tier 3 public engagement meetings, from my perspective, as far as the one in Newport, I wasn't hearing a lot of direct feedback concerning the proposed rule, as far as the specifics of it, the tier 3 resources, etc. Like, so that was, I don't know, one might say kind of unfortunate in a sense of not, like the public inputs were not fully aligned with, some elements of what, we were hoping to get input on with respect to the draft tier 3 rule, at least from my perspective. Like, there wasn't a lot of focus there, but it is what it is, right? Like you provide this opportunity for people to tell you what's on their mind, and that's all good and welcome it. And so.
But Kirsten, I think that's a really good point. I'm so glad you brought that up because you're absolutely right. And in my mind, as somebody who's done community planning for a long time, it belies the need to do more, right? So what happened over the last 2 weeks with these public engagement sessions was just for people to be able to say, wait, what? And to ask questions and to get some explanations. And it's what happens next that I think will be specific feedback on the draft rules. There'll be plenty of folks who are just going forward are still going to make the same points about general concerns and cost and those sorts of things. But I think that the specific comments will flow as long as we provide additional opportunities for people to provide those specific comments, which I will make sure we do.
Thanks, Alex. Sarah?
So just a couple of things, and I think the first thing to sort of follow up on the previous conversation is some municipalities have really strict regulations around and requirements about what can and cannot go in with the tax bill. And I think the other thing to look at is there are municipalities that sometimes will combine different parcels into one tax bill. And so that is not a very sharp or on point effective tool, because you as a property owner might get something then and wonder which, or is it all properties? It could be 4 or 5 properties. So I want to first recognize that that's sort of a blunt tool, and there's nothing, I'm not sure of a good way or a good solution on that front. I think the other thing that I want to contribute was a little bit of a missing piece of conversation, and just sort of connect the dots to have this discussion for the board, is at the one that I was at, a person brought up the fact that the data that we're using that was collected as part of significant communities was told to the property owners of, we will not use this in a regulatory way. And here we are. And I know the reason why we're here is because we really don't have too many other good options or other good data sets to pull from. And we are looking at using this data in a regulatory way, which I think some were concerned about the detrimental effects that this could have on the property owners that were willing to be goodwill partners with us in terms of providing this data to the state. And so that's what I think, sort of connecting the points, is that's all the more reason why I think we should be trying to exert every effort to notify property owners, is to re-engage them and sort of help fill in the missing links about how we got from point A to point B, where we said we weren't going to use this in a regulatory way, to, yep, we are considering using this in a regulatory way. We want to bring you back in and give you the opportunity to participate and absolutely hear from you. So I think that's sort of strengthens the reason why I'm in the, yes, we need to try and notify, but realizing there isn't a good tool set to use on that front, and also the added expense.
Thank you, Sarah. Brooke, you have some to say on this point?
Yeah, I just want to give voice to the biggest concern that I heard at the Tier 3 meeting, and that is folks feeling like not only is this going to devalue their property, but also create cost if they want to develop their own property. And it was very concerning to hear about that. And I've been trying to think in terms of, everything from EJ. I mean, what they feel is, everyone over there is being given incentives to build, and I am in a disincentive situation. But not only that, I've now lost value because you're drawing a map line on my property. So the reason why I bring this up is that, I like bright lines. And I have all right from the get-go been very staunch in my position that if it's Act 250, we trigger jurisdiction and poof, you're in it. I would be willing, however, to think a little bit more brainstorming about Tier 3, because I have some real concerns about what I heard from the rural folks that feel that this is a morass that they're being involuntarily thrown into. And so I would be willing to give some thought to some kind of pared down, easier process. I don't know. I'm just throwing it out because I want to express not only their voice, but my concern about how they feel about that. And if there's anything we can come up with to try to mitigate the financial impact to folks, I think that we should put our heads together and see if what we could come up with.
Thank you, Brooke. We have 1 minute left on this before our next agenda item. Kirsten, do you have something that won't take too long?
Yep. So just
Okay.
quickly to add on to what Brooke was saying, or related to that, and again, this occurred in Newport. And it was actually via Jamie Fidel. He was participating remote, and he asked if the board had considered the possibility of having, an application process that focused on a subset of the criteria when jurisdiction is triggered due to Tier 3. And my interpretation of his statements were that he supported that concept. And perhaps that will be something someone proposes to the legislature, and we should just be thinking about, how we would, what we think about that. He specifically wanted to notice the board had, like, my interpretation of what was said was, do we have a position on it? Is it something we're coming forward with? Because right now it's, if you need an Act 250 permit, you have to satisfy all of the criteria in one manner.
Right, and that was talked about early in the stakeholder process, as I recall, Alex, and we moved away from a separate sort of consideration there for the reasons that Brooke initially had and that others had. Coordinators and had given this input that it should just be an either you're in or you're out, and it's the whole thing. So I'm not sure there has to be a legislative change. It could be part of the rulemaking. And before we move on to the next agenda item, can we hear from Annette?
Yes, I've seen that draft legislation, and perhaps you might want to talk to the people in the rural caucus proposing it. If you haven't seen it, Vermont Center for Geographic Information has a uh, Vermont property transfers map. It covers everything from 2019 through the present. I highly recommend looking at it. It's really quite shocking how many property transfers have occurred. A lot of them are for $0 from one person to another. But the idea of doing a statewide mailing to everybody in tier 2 and tier 3 is, I've seen enough problems just notifying adjoiners to projects, and the cost. But this is something that the rural caucus appears to be moving forward with. And on that other point that was just mentioned, I've related to Alex about it. And my experience is Act 250 doesn't always consider all the criteria anyway, but that this would potentially create a loophole for some to say, oh, I can go through tier 3. If I have tier 3, then I get exempted from aesthetics. I mean, it doesn't make any sense at all to me. And I'm not sure. Well, Jamie did say why he was proposing it, and that was because he realized there was going to be a lot of pushback on tier 3, and he thought maybe this would help build support for tier 3. But I will share, I attended all 4 meetings. I will share my observation, which I know Kirsten is correct, that hardly anybody actually provided any input on the actual proposal. And so what I would hope that will happen as a result of it is that more people will actually look at the map and look at their areas, which is what I did, to see where there are issues that need to be addressed. And frankly, some of the people who spoke, and in particular, one of them, a developer, talked about, well, I have all these parcels, but one would almost have all this stuff in tier 3, and I'm thinking, well, okay, maybe you should rethink whether you want to develop there. And so just the idea that people are being prohibited from developing in tier 3 areas should result in a thought process that says maybe there's a good reason not to develop in those areas. Maybe these are areas. So that's the part of the conversation that I was looking for that I'm not seeing, is the support for ecological protections. Thank you.
Thank you, Annette. So we're going to move on to the next agenda item, which is discussion of appeals enforcement and attorney-client communications. Do I have a motion? Brooke?
Waiting for Word to open. Hang on. Okay. The board needs to discuss pending and probable Act 250 appeals and enforcement actions, and to have confidential attorney-client communications on these matters. I move that we find that premature public knowledge of these matters would place the board at a substantial disadvantage, and that the board enter executive session.
Thank you.
Second.
Thank you, Sarah. Any discussion on that motion? Okay, hearing none. All those in favor, please say aye. Aye.
Aye.
Aye.
That is 5 ayes, which means it's unanimous. So the board will go into executive session, after which they will return to this meeting venue and prior to adjourning. So see you soon. Okay, the recording is still in progress and we are all back. Alex, I believe you have a motion.
Yes, regarding enforcement matter or enforcement case number 2016_001. I move to authorize enforcement to transmit a proposed assurance of discontinuance, impose a $4,000 civil penalty, and seek reimbursement of $1,337.34 for enforcement costs incurred.
Thank you. Do we have a second?
I'll second.
Thank you, Brooke. Any discussion? Hearing none. All those in favor, please say aye. Aye.
Aye.
Aye.
And Kirsten, are you recusing?
I'm recused and
abstaining.
abstaining from the vote.
Okay, thank you. So that is, that motion passes
I'll move
with
to
one
adjourn.
abstention. Oh, thank you, Brooke.
I'll second.
Thank you, Sarah. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
See you all later.
Thanks, Pete.